Judge Ural Glanville. Judge Ural Glanville. I hold you in contempt. I hold you in contempt in the space of public opinion. When your lawyer who is defending you then needs a lawyer because he's jailed in the courtroom, this is absurd. This is beyond the pale. Judge Ural Glanville, how could you? You have displayed the corruption which is taking place in Fulton County. No, you cannot do this. In this YSL Young Thug trial, RICO, that is taking place, Judge Ural Glanville held the lawyer defending Young Thug in contempt. And it is having major implications and could even cause a mistrial. Under the fair use doctrine, the Law and Crime Network has more. And I'll be back to provide further commentary.
And it doesn't end there. No, of course, there was recently when Young Thug's lawyer, Brian Steele, got in trouble. He was held in contempt of court. And this was a very, very controversial move and drew the ire from many in the legal community. So Brian Steele had become aware that an apparent private meeting took place between Judge Glanville, prosecutors, and a key witness named Kenneth Copeland. It's called an ex parte meeting. It's in the judge's chambers. Defense counsel was not alerted of this meeting. They were clearly not present for this meeting. And Steele took issue with this because he claimed that his client should have been privy to this, especially since Copeland, who is going to potentially testify about Williams' involvement in the murder of Donovan Thomas, was allegedly threatened by prosecutors and the judge in order to testify, and claimed that he would testify that he was responsible for Thomas's murder, that he wouldn't tell the truth while on the stand. So very important information that allegedly happened behind closed doors. Well, Judge Glanville didn't seem to focus so much on the content of the meeting as much as he was upset about how Brian Steele found out about it. So Brian Steele complains about this meeting, and then let's hear what happens.
And then somehow that email was CC'd. To me, that never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm not disturbed too. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why would you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based on information...
Okay, well listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards
coercion taking place in Fulton County with the judge in a meeting with a witness, a prosecution witness, coercing him to testify, or else they would jail him until every single member of the supposed YSL involved in this case would be tried, meaning that they coerced him to testify or he would be locked up. Under the fair use doctrine, I'll continue. Law and Crime Network.
I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is why wasn't I there Why?
Sir, I'm going to hold you in contempt if you don't tell me who this. Tell me who this
I
information
don't
is
want to
coming
be held
from.
in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information.
So the judge called for a 5-minute recess, and when he came back, he still demanded to know how Brian Steele had learned about this private meeting in his chambers and what was said. And this is where it gets complicated, because it seems Steele is saying, you're giving me an impossible choice here, Judge. If I tell you, I violate the ethics rules. And if I don't tell you, I'm going to be held in contempt of court?
You need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
And
The judge clearly showing signs that he's a mobster, threatening the defense attorney. If you don't tell me what I want to know, I'm going to hold you in contempt and you will be jailed. This is improper. I would never want to have any trouble in Fulton County, because if somebody with the means of Young Thug that can hire a top tier lawyer be in a position where his own defense attorney could be held in contempt and could be jailed, that is what, or how rather, the system can be rigged against someone. This is where the system is rigged. This is where the system is rigged. I will continue and provide further commentary.
Santa, I don't want to be held in contempt.
Now, I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
You've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not. I'm
The issue is
The judge here now, he's straying off the issue. He's projected. He's straying off the issue. Why is it he addressing what Steele is saying? He's straying off the issue. He had an ex parte meeting with the prosecution witness who was already sworn in days prior. Why is he meeting with him separately, and then this witness decides, well, they're not going to testify without the defense attorney having been in that meeting? The judge made a huge mistake here, and it is a reversible error, as Ashley Merchant, a top-tier lawyer out of Georgia, would say later. I'll continue and provide my final commentary on this topic.
Come on.
you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you.
Okay, but
saying,
the
threatening me with contempt.
privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not some substance, but I'm telling you I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be.
So this Judge Glanville out of Fulton County, out of Georgia, actually did hold Steele to contempt. What ended up happening was Ashley Merchant, who is the head of a group of lawyers, set up to defend lawyers in situations like this, which is a rare occurrence, actually came into the courtroom, tried her best to convince the judge to drop it all, but then to allow later for Steele to be bonded out in the supersedious bond, which he didn't grant. He sentenced Steele to 20 days, and what ended up happening was a Georgia appellate court then granted Steele the supersedious bond. But I can't imagine being a defendant in a case where a judge would jail my own lawyer. That is the system that is just talked about, how unfairly it is. And for someone even with the means as a young thug to have his lawyer jailed, it just really shows you that, hey, you really can't get in trouble, because if the system is engineered in such a way where there's so much corruption taking place, wow, you can't ever get caught up in the system. And that's the lesson that I take from this. It's just atrocious what I've seen within these past few weeks in that Fulton County courtroom. But the question is this happening all over the country? And especially with people who do not even have the means as a young thug to defend themselves. What about their situation? So I'm going to leave it here. I'm Damien Jordan. Thank you for watching.